Important Bar Rules Series. Torts.
Intentional torts. Intent. Intent is established when the defendant acts with the desire or purpose to achieve an outcome, or with knowledge to a substantial certainty that the outcome will result. Transferred intent. Transferred intent is a substitute for intent when the defendant has the necessary intent against one person but instead commits a different tort against that person or another person, or the same tort against another person. Battery. Battery is the intentional infliction of a harmful or offensive contact against the body of another. Assault. Assault is the intentional infliction of an apprehension of an imminent harmful or offensive contact. Apprehension requires that the plaintiff be aware of the threat. False imprisonment. False imprisonment is the intentional confinement of a person to a bounded area from which there is no reasonable means of escape, and the person is aware of the confinement or harmed. Trespass to land. Trespass to land is the 1. Intentional. 2. Physical invasion of land of another. Intentional infliction of emotional distress. Intentional infliction of emotional distress is 1. The intentional or reckless. 2. Infliction of severe emotional distress. 3. Caused by the defendant's extreme or outrageous conduct. A third party who witnesses the act, but is not a direct target of the conduct, can still recover if they were present and the target was a relative, or if they were present, known to be present, and suffered physical harm. Defenses. Self-defense. A person is entitled to 1. Use reasonable and proportionate force. 2. When they reasonably believe it is necessary to prevent. 3. Threatened harm. The use of deadly force is only allowed if the defendant is reasonably in danger of death or serious bodily harm. A person may use only the degree of force necessary to prevent the threat and must retreat if possible. Under the Castle Doctrine, a person is not required to retreat if they are in their own home and defending against an intruder. Consent. A plaintiff may not seek relief if they consented to the conduct. The conduct must be within the scope of the consent. Negligence. To establish a prima facie claim of negligence, the plaintiff must show that the defendant's conduct posed an unreasonable risk which resulted in harm. The plaintiff must establish duty, breach of duty, actual causation, proximate causation, and damages. Duty. Duty of care encompasses both 1. The people to whom the duty is owed, and 2. The standard of that duty. In the majority Cardozo view, a duty is only owed to those foreseeable plaintiffs within the zone of injury. In the minority Andrews view, a duty is owed to everyone. Standard of duty. The defendant must act as a reasonably prudent person under the circumstances. Negligence per se. Both duty and breach can be established if the defendant violated a safety statute. The plaintiff was in the class of persons the statute was intended to protect, and the harm was of the type that the statute was intended to prevent. Children. Children have a duty to act as a reasonable person of the same age, unless they are engaged in an adult activity, such as driving. Breach. A person has breached their duty if they fail to conform to the standard of care. Res ipsa loquitur. Res ipsa loquitur establishes breach of duty, even if the conduct cannot be identified. If the harm is of the type that does not occur absent negligence and the instrumentality responsible for the harm was under the defendant's control. Actual causation. Actual causation requires that the harm would not have occurred, but for the defendant's conduct. Proximate causation. Proximate causation requires that the harm was a reasonably foreseeable consequence of the defendant's actions. The harm can be unforeseeable if the harm was a result of superseding or intervening events that could not reasonably be foreseen. Damages. The plaintiff must establish actual injury or damage to property. Purely economic harm is not recoverable. Negligent infliction of emotional distress. The defendant is liable if he engages in negligent conduct that causes the plaintiff to suffer severe emotional distress. The plaintiff may recover under a direct or bystander theory. Under a direct theory, the plaintiff is the victim of the negligent conduct. If the plaintiff suffers an impact, the emotional distress is considered a parasitic damage to the physical harm. If there is no physical harm, the emotional distress is the measure of damages as long as the distress is extreme. CA. Or if there is a physical manifestation of distress. Majority. Under a bystander theory, a plaintiff may recover for an impact to a close relative if he observes the danger. CA. Or is in the zone of danger. Majority. Comparative fault. Most jurisdictions have adopted a comparative fault doctrine that limits, but does not completely bar recovery. The degree of limitation depends on the proportion of fault and the jurisdiction's rule. California has adopted a pure comparative fault rule that assigns recovery based on the proportion of the defendant's fault. Strict liability. Strict liability is liability without the need to prove duty and breach. Abnormally dangerous activity. The operator of an abnormally dangerous activity is strictly liable for harm. 1. If there is a high risk of harm. 2. The risk cannot be reduced with due care. 3. The activity is not common or appropriate for the location. And 4. The risk is greater than the value. Strict products liability. A seller of a product is liable without the need to prove duty and breach for any personal harm caused by a defective product. The plaintiff must establish that 1. The defendant was a commercial supplier. 2. There was a defective product. 3. The product was the actual and proximate cause of the harm. And 4. Damages occurred. A defective product can be established by a manufacturing defect, a design defect, or a warning defect. Manufacturing defect. A manufacturing defect occurs when the particular product is more dangerous because of a material deviation in design. Design defect. A design defect can be shown by 1. The consumer expectation test, which requires that the product meet the minimum safety expectations of its ordinary users when used in a reasonably foreseeable manner, including misuse. 2. The risk utility test, which requires that risk inherent in the design outweighs the benefits of the design, or that there was a reasonably feasible alternative design that was less risky. A warning defect exists when the maker fails to provide adequate warnings about known dangers. Actual causation. The harm would not have occurred but for the defective product, and the defect was present when the product left the defendant's control. Damages. Physical injury or property damage must be shown. Like negligence, there is no recovery for purely economic loss. Nuisance. A private nuisance is the substantial, unreasonable interference with the use and enjoyment of one's land. A public nuisance is a substantial, unreasonable interference with the health, morals, welfare, safety, or property rights of the community. Defamation. Defamation is 1. A false and defamatory statement. 2. Of or concerning the plaintiff. 3. Published to a third party. 4. Causing damage to the plaintiff's reputation. Libel. Slander. Libel is written or printed defamation. Slander is oral defamation. For libel, damages are presumed. For slander, special damages must be proven unless the defamation was slander per se, meaning the statement 1. Accuses the plaintiff of a crime. 2. Having a loathsome disease. 3. Being unchaste. Or 4. Unfit for business. Private figure. Public concern. If the plaintiff is a private figure but the statement is of public concern, the plaintiff must only show that the defendant acted with negligence, and can only recover actual damages, unless actual malice is shown. Damages may be presumed, and punitive damages may be awarded. Third-party issues. Vicarious liability. Vicarious liability is when a third party is held responsible for the tortious act of another based on a special relationship between the tortfeasor and the third party. Respondit superior. An employer is liable for the tortious acts of his employee if the employee commits a tort while working in the course and scope of employment, but not for tortious acts of an independent contractor. Actions are within the scope of the relationship. 1. If the conduct was of the kind the agent was hired to perform. 2. The tort occurred while so acting. And 3. The agent intended action to benefit the principal.